Welcome back. We've got a situation we've talked about before here up in Illinois where the state many years ago passed a parental notification bill saying that parents have to be notified, this radical thought that a parent should know if their 12-year-old daughter is down at the Planned Parenthood having an abortion. The state passed it. The pro-aborts fought it. It finally wound up in the court system. The courts ruled it's constitutional, and they even gave it a date that it had to start being enforced.
Right.
Now the pro-aborts have got it held up again, and the attorney involved in this case is a very good friend of ours, been on here several times before, Tom Brecka. And Tom joins us now from Chicago. Hello, Tom.
Yes, hi, Mark. How are you?
Listen, what is the deal here? I thought this was settled business.
Well, it certainly should have been after, 11 years. Last summer, the Court of Appeals upheld this law finally. We got some procedural rules that were lacking 10 years ago, and the Illinois Supreme Court, which refused to issue those rules for reasons that didn't make any sense, finally, 6 out of the 7 members were new, so we asked them to issue the rules, and they did. Huh. And the ACLU came up with another attack on the parental notice law, and the problem, Mark, is that our Attorney General and some of the other officials in Illinois leaned too far in the wrong direction. And the Attorney General didn't make a very good response to that new challenge, and the judge upheld it. So there was another 2-year delay until last summer, but we participated in that appeal and kept their feet to the fire. They did a better job on appeal. Finally, the law was okay, ready to go. But lo and behold, the Medical Disciplinary Board, on its own, issued a suspension. They said, we're not going to enforce this law. They're the ones who are supposed to penalize doctors, that is abortionists, who don't obey it. They said, we're going to give them another 60 days so they can figure out how to comply with this law. Well, we screamed bloody murder. We said, my God, you've had 14 years. You don't need any more time. We went up to the Illinois Supreme Court and asked them to intervene directly, and they said, well, you go down to the trial court, and by then the 60 days were about up. We got a couple of strong dissents, and the medical disciplinary people tried to extend it another 6 months, but with all the publicity we generated, some of their members actually said no. So it looked like the law finally would go into effect. But ACLU filed a new lawsuit, and this time they went to what we lovingly call the Circuitous Court of Cook County, Illinois, and they got a nice Democrat-Irish judge to issue an injunction based on the state constitution in Illinois, supposedly guaranteeing a right to abortion that is stronger than Roe v. Wade and the federal right to abortion. And he issued a new restraining order.
Well, Tom, no one is saying these girls can't have an abortion.
Well, that's right. Mark, it's simply a notice law.
Right.
Consent still reposes with the young woman, and, she can go into court and even avoid notice. That was these procedural rules that were handed down. So the whole thing is really a power play by the abortion lobby in our state because, let me tell you, there simply is no state constitutional right to abortion in Illinois. The record couldn't be clearer. The Constitutional Convention 3 years before Roe v. Wade was handed down said that they weren't going to touch the issue. It ought to be left to the legislature. There's no question about it. And for the judge to rule there's a fair question is really an abomination. So we're going back in to ask him to fix this up, and if he doesn't, we're going to take an immediate appeal.
Well,
and fight this thing.
Is this Daniel? I noticed this Daniel Riley is his name.
Yes, Daniel Riley, and went to Leo High School, nice Catholic fellow, supposedly. But, the Democratic Party in Chicago seems to prevail against anybody's religious faith. He apparently doesn't, and this isn't a matter of whether you're pro-life or pro-abortion, really. This is a matter of following the rule of law.
Right.
So they're bending that law, and
Well, that's
and the
their
Attorney
history.
General is not even defending whether there's Roe v. Wade in Illinois. She's saying that, well, if we have an abortion right, assuming we do, it's no stronger than the federal right. That's a weak-kneed defense, and there's a real need for us to get in there and scream.
Well, I know you're the kind of guy that can take this. I mean, you're you're the attorney who won for Joe Scheidler in the Now versus Scheidler fiasco. So we got
thanks, Mark. That took 20 years. I hope this one will. We'd like to be a little quicker in this one.
Hey, at our age, Tom, we won't be here to see the end of it if that's the case.
I hope we will see the end, Mark.
Well, I hope so too. Well, thank you for coming on and updating us, Tom.
Thank you very much.
Thank you.
Yeah, bye-bye.
And we appreciate what you're doing up there, sir.
Thank you.
Bye-bye, sir.
Tom's a great attorney.
He is,
And
really.
the thing about these notification laws or 24-hour waiting laws is it boils down to putting hurdles in front of women, make them pause and think. And we know when these are enacted and enforced, number one, babies are saved. A certain percentage of babies are saved. But number two, and my favorite thing, is that we know that these abortion clinics and the medical disciplinary boards won't enforce them, and it gives us a tool to go in there and prosecute these guys.
Well, and you know, it's more example here of the fact that these people claim they care so much about women and these young girls. They are lying through their teeth.
They want to have an informed
I don't care what
choice.
anybody tells me. If anyone who tells me that the typical 12, 13-year-old girl who's pregnant and thinking about having an abortion is better off if her parents don't know about it is a bald-faced liar.
No, the people that are forcing this abortion agenda not only say that their parents shouldn't know, they're saying that she shouldn't see a sonogram picture of her baby. She shouldn't know what sort of drugs go into her body. She shouldn't be informed of what type of procedure is going to be informed. She shouldn't be informed of the fetal development of that baby. She shouldn't be informed of anything except for how much money she needs to pay.
Or the consequences for her down the road.
And we could go on and on about that. Because the abortion industry has one thing to sell, and it's a dead baby.
It's get her in the stirrups. That's the goal.
And they don't mind exploiting women. They want to even exploit young girls. And that's what people got to realize. These people are exploiters to the nth degree.
Right. Well, we had the story earlier about in Arkansas, 14-year-old girl being prostituted to a series of men. She gets pregnant, takes her to the abortion clinic. They just abort her and send her on her way. She's back in the prostitution business.
So it's Planned Parenthood that treats women like a slab of meat.
Right, exactly.